Students, I welcome you all to the lecture number 2 of the Sale of Goods Act 1930, which is a part of CA Foundation lecture series sponsored by Sri Jendra Rank Zone. I'm your mentor, Shekhar Gehlot. So, in the previous slide, we discussed about the definitions provided in the SOGA Act. Okay, SOGA or Sale of Goods Act. We did wholesome level of definitions, which are very much crucial in understanding the real import of the Sale of Goods Act. Okay, now in this unit we will discuss about sale and agreement to sell and its implication and different types of sales, and we will distinguish sale from other type of transaction which appear to be a sale but may or may not be a sale. Okay, may or may not be a sale, and it assumes a very cruciality as per the Sale of Goods Act is concerned, because here we are concerned only and only with sale. Okay, we are concerned only with the sale. Okay, so according to section 4.1, a contract of sale of goods is a contract whereby the seller. Now, what kind of contract is a contract of sale? A contract of sale of goods is a contract whereby what happens in this contract is whereby the seller transfers. Now the seller is transferring. Okay, the seller transfers, or or it is not and, it is or. Okay, seller transfers or agrees to transfer the property in goods to the buyer for a price. Okay, now we are discussing two situations here in this part definition. First is where seller transfers. Seller transfers, that means we are dealing with a situation which is a present situation. Okay, which is a present situation in which the seller has already transferred. He has already transferred. I go to a grocery shop. I tell him, give me one packet of Tata tea. He takes money and gives me Tata tea. Now the transfer of property has happened then and there only. It's a pure cash transaction happening at the spot. That is this is a contract whereby the seller transfers. Seller has transferred me the goods. Okay, what is the good here? Good is tea. Okay, now or agrees to transfer. Now or agrees to transfer. Agrees means he agrees that he will transfer. Agrees to transfer is a future transaction. Future transaction. So he agrees to transfer me. Now I go to a farmer. Now because the Modi government has brought some changes in the legislation in the farm bill, I go to a farmer. Now I can go to a farmer and have a contract farming. I contract with him that after 4 months upon the harvest season, you will supply me say 100 quintals of potatoes. 100 quintals of potatoes after 4 months, and he agrees to that. Now he is a seller. I am a buyer. The farmer is a seller. He agrees to transfer. What is the property? He agrees to transfer 100 kg, 100 quintal of potatoes to me after an expiry of 4 months. So now the sale will take place in future. Okay, and both of these situations, present as well as future, is taken care of by a contract of sale of goods. Okay, the contract of sale of goods is complete. It contemplates two situations. One is at present, other one is happening at future. There may be a contract of sale between one part owner and another part owner. Okay, there may be a contract of sale between one part owner and another part owner as well. Like suppose I am a joint owner of 1 acre of land with my brother. Okay, with my brother. So my father had 1 acre of land. Now after my father, me and my brother, we jointly hold that 1 acre of land. So now whatever crop is growing on that 1 acre of land, I am also a part owner of that crop. My brother, being another part owner of the land, he is also part owner of the crop. So there may be a contract between two part owners as well. I may have a contract with my brother for sale of his portion. Okay, for sale of his portion. Okay, so that is also very much applicable and taken care of by the Sale of Goods Act. A contract of sale may be absolute or conditional. It may be absolute or it may be conditional. Okay, absolute is, what is absolute? When it is happening then and there. Okay, when it is happening without any conditions. I want I want a car, you sell me this car. What is the price of the car? This is the price of the car. Okay, I pay you price, you give me car. That is an absolute sale. Okay, that is an absolute sale. Or there may be conditions like if you buy my car, you will have to get insurance done regularly. You will have to get your pollution checked. Okay, and from my company only. That may be a conditional sale. Okay, this is a conditional sale. Or we'll do some other examples as well. Okay, like sale via installments. Okay, sale via installments is a conditional sale. It is a keyword nowadays, very much popular practice. It's in common parlance, it's known as EMI sale. Okay, you buy something on EMIs. EMI stands for easy monthly installments. Okay, you keep on paying your amount in equal monthly installments. Slowly and steadily, you keep on paying up, you keep on building up. That is the way you make a sale transaction happen through conditions. Okay, this is a conditional sale. The moment you stop making the payment, the property will again revert back to the seller. Meanwhile, you are paying the installments, the property will remain with you. Where under a contract of sale, the property in goods. Okay, where under a contract of sale, the property in goods is transferred from seller to buyer. Okay, now the property has been transferred from seller to buyer. The contract is called a sale. This contract is called sale, where the transfer has taken place. It is sale. Sale has taken place. Sale is final, fully done. It's complete. Nothing more is left to be done as far as sale is concerned other than transfer of property. Okay, so transfer of property has taken, the contract is called a sale. But where the transfer of property in goods is to take place at a future time or subject to some conditions thereafter to be fulfilled. It may be a situation where transfer of the property will take place at a future time, like we discussed the future sale of potatoes by a farmer after 4 months when the onset of the harvest is there. Okay, so uh, thereafter to be fulfilled, okay, or subject to some conditions. Some conditions may be like equal monthly installments. Once they are fully paid up, then you can become true owner, or the property will pass on to you. In true sense, the contract is called an agreement to sell. Okay, so sale is when it is final transaction is done, finally it is done. Or agreement to sell is when it is yet to be done on a future date, or some future occurrence will decide whether the sale will be complete or not. An agreement to sell becomes a sale when the time elapses, okay, or the conditions are fulfilled subject to which the property in goods is to be transferred. An agreement to sell becomes a sale. It becomes a sale, okay, when the time lapses. What kind of sale will become a complete sale on the lapse of time? Okay, on the lapse of time, we may very much have a example, very current example nowadays. We have some online shopping platforms known as Amazon or Flipkart or Mintra. Excuse me. We have online shopping platforms.
It's 11 o'clock.
Okay, suppose let's say the case of Amazon. Okay, Amazon gives you a deadline of 30 days. If you purchase a shoe, or I purchase an apparel from Amazon, I purchase a t-shirt. Suppose I purchase a t-shirt from Amazon. Amazon will say within 30 days of the delivery, you can return it to us and we'll pay you your money back. No questions asked, flat. We will not ask you any question as to why you are returning it. You may return it with any reason. We'll not go into your reasoning process, but within 30 days, if you'll return it to us, we'll pay your money back. Okay, so now I have ordered a t-shirt. Now I have got the t-shirt. I wore it. I like it. I did not give it back within 30 days. So after the lapse of time, the sale would be complete. Okay, after 30 days, after 30 days, when I do not return the product to Amazon, sale is complete. Okay, so this kind of sale is sale which is completed by lapse of time. Okay, or to the conditions fulfilled. Conditions may be like you have taken something on loan, okay? Loan transactions, okay? You have to, one must pay all EMIs before before sale becoming final. So this is a conditional sale. Other one is a sale on the lapse of time. Sale on the lapse of time. Now we will make an analysis. We'll make an analysis, okay, of this aforementioned statement. A contract for sale may be either sale or an agreement to sell. Now, what is sale? What is sale? Let us see it as per the act. Okay, let us see it as per the act. Though we have discussed it, but it is imperative that we must also know the point of view of the act. In sale, the property in goods is transferred from seller to buyer immediately, like we discussed that. The transfer happens immediately. There is no wastage of time at all. You go to the store, you buy something, you pay the money, you own the product, the property is transferred to you, delivered to you. That is immediately. The term sale is defined in section 4.3 of the Sale of Goods Act 1930 as, now how the sale is defined. Okay, where under a contract of sale, where under a contract of sale the property in goods is transferred from seller to buyer, the contract is called sale. The contract is called sale, where you have a contract of sale and the property in goods is transferred from seller to buyer. Property in goods, okay, it is not the goods. We are not talking about transfer of goods, okay. There there is a difference between, okay, there is a difference between both of these statements. One is transfer of goods, other one is transfer of property in goods. Okay. Now we have discussed it. Transfer of goods means physically you have to transfer the goods. Like buy I buy a TV set. Okay, I buy a TV set. Immediately he'll hand over it to me. Okay, I'll take it, I put it in my car and zoom away. This is immediate sale is happening. Okay, immediate transfer of goods. Physical delivery of goods is happening. But now say take it in the context of a commercial transaction. Okay, because Sale of Goods Act is dealing with commercial transactions, and commercial transactions are usually of very high quantity. So now I go to a dealer and I tell him that I want 100 TV sets. Okay, 100 TV sets. Now 100 TV sets, he cannot simply pack them at the moment and place it in my car. Okay, it is not possible. He'll say it's okay. You make the payment. I'll do one thing. I'll put it in the truck and truck will dispatch it to your godown within 3 days. Within 3 days. Okay. So now the physical delivery of TVs will take place after 3 days. Okay. But the transfer of property in goods has taken place. Okay. The transfer of property in goods has taken place, meaning thereby that I have become the owner of those 100 TV sets now. I am an owner of those 100 TV sets. Okay, no one can deny me those 100 TV sets. I have earmarked those 100 TV sets. The seller has placed those 100 TV sets separately for me. Now he is just a custodian, he is only a guardian. He is holding those 100 TV sets only for me. If tomorrow something happens to them, some damage is occurring to them due to the fault of this person, I can sue him. Okay. So he is only a caretaker now. I have become the actual owner. I can go and take them anytime I want. If I have a truck with me, I can then and there get them. Okay. But because I do not have a truck right now, so the seller will supply it to me, but it will take 2 to 3 days. But transfer of property in goods. Okay. Transfer of property in goods has passed to me. Okay, I have become the owner. So this is also a sale. So when they say the sale is transfer of property in goods. It's not transfer of goods. Transfer of goods may or may not be there. It may be happening after some time, say a month, but sale is complete when transfer of property in goods happen. That is to say, when ownership is changed. Okay, then the sale is complete. Physical delivery may take place after some time. That is immaterial. Agreement to sell. Next is agreement to sell. In an agreement to sell, the ownership of goods is not transferred immediately. Okay, in an agreement to sell, it is because only an agreement to sell, it is not a sale. Transfer of goods will take place immediately only in sale, but in agreement to sell, it is not a sale. It is only an agreement that we both have an understanding that you will purchase this thing and I will sell this thing. That is an agreement to sell. Only an understanding is there. Okay, agreement means mutual understanding. So there is only a mutual understanding regarding sale, but sale is yet to take place. Okay, so therefore, because sale has not taken place, there is no transfer of property in goods or no change of ownership. Okay, it is intending to transfer at a future date. Agreement to sell will always operate on a future date upon the completion of certain conditions. Certain conditions are there, like you have to make the payment this and that bank account or through cash, or it has to be of that paint, it has to be red color car, it has to be a black color TV, it has to be plasma TV, like this. Okay. The term is defined in section 4.3 of Sale of Goods Act as this term agreement to sell is defined as where the transfer of property in goods is to take place at a future time. Okay, where the transfer of property in goods is to take place at a future time or subject to some condition thereafter to be fulfilled. Okay, the contract is called an agreement to sell. It's a understanding that we will conduct a sale, but definitely transfer of property and goods will take place at a future time or subject to certain conditions being fulfilled by either party. That is agreement to sell. Thus, whether a contract of sale of goods is an absolute sale. Okay, thus, whether a contract of sale of goods is an absolute sale or an agreement to sell depends on the fact whether it contemplates immediate transfer from seller to buyer or the transfer is to take place at a future date. Okay, so in both the cases, contract of sale is there. Okay, contract of sale is there, but whether it is a sale, okay, or whether it is an agreement to sell, okay, these are both part of contract of sale. So whether a contract of sale is actually a sale or a contract of sale is an agreement to sell will depend upon the facts. What are the facts of the case? Whether the transfer of property is happening immediately, it is a sale, or in case the transfer of property in goods, okay, not transfer of goods, transfer of property in goods is supposed to happen on a future date or upon completion of certain conditions. In that case, it is an agreement to sell. Now, when an agreement to sell becomes a sale, okay. Now we know agreement to sell, we know sale as well. But when would an agreement to sell become a sale? An agreement to sell becomes a sale when the time elapses, like we discussed in the case of Amazon or Myntra, or the conditions are fulfilled, like I want a red color car when the car is painted red, subject to which the property in goods is to be transferred. Okay, subject to which, because property in the goods is to be transferred after fulfillment of these conditions or after fulfillment of the time. Okay, so now the agreement to sell will culminate into sale. It will become a absolute sale, full and final complete sale. The following elements must coexist so as to constitute a contract of sale of goods under Sale of Goods Act under SOGA. These are the essential elements which must be prevalent, which must be available whenever there is a contract of sale. Okay, these are the essential elements of the contract of sale. First one is there must be at least two parties. Okay, the seller and buyer. There should be two parties. I cannot make a sale to myself. I cannot be a seller or buyer myself. Okay. There has to be two parties. This is a matter of common understanding, needs no further discussion. Now, why this point is important to understand, because in a case, what happened? Uh, in a case, what happened? A Okay, now why this situation is important? There was a case in which this is a case I'm discussing, the facts are real. A, B, and C were partners in a partnership firm. Okay, now there are three partners A, B, and C. Okay, now somehow after operating their partnership for some years, say they felt like closing down or shutting down their partnership. They thought that their partnership was not yielding good results, so it is better that partnership should be put off. So they decided to shut down the partnership. Okay, now because now partnership has some assets, okay, it has some car, it has some office furniture, it has table, it has things like that, so they decided to close down the partnership, and then they divided the assets of the partnership among themselves. Okay, A took some, B took some, and C took some other. Now what happened, sales tax commissioner who was residing, who was having jurisdiction over A's area, he decided to put tax upon A for sales tax. He said, you have made a sale, okay, you have made a sale to B and C. Okay, now you must pay a sales tax. A said, I have not made any sale. Why should I pay a sales tax? So the matter went to the court. The court finally decided that because partnership, the nature of partnership is such that A, B, and C, they are all co owners. I'm not saying joint owners. We can have a sale between joint owners. Joint owners can have a sale transaction, okay, because they know their share. Okay, their share is divided. But when you are co-owners, when you also own a thing and your share is not yet divided, you own the thing completely, you are a co-owner, so now you are dividing things between yourself. Okay, that's okay, you keep this, I'll keep that, you keep this, I'll keep that. Okay, in that case there is no sale happening. Sale is not happening because whatever he has received it as an owner only. He was owner. He was an owner of that farm. Whatever assets have come to his share, he already owns them. He is an owner of partnership. He's a partner. Partner being a partner being the owner of the partnership. He is the owner of the goods as well. So the court said that the contention raised by the sales tax commissioner is not valid in the law because for sale there has to be at least two parties. One party cannot be a seller as well as buyer himself. Okay, so now that is why this particular point assumes significance, because there may be some transactions in which it may appear like a sale has taken place, but actually there was no sale at all. The subject matter of the contract must necessarily be goods covering only movable property. Okay, the subject matter of the contract must necessarily be goods covering only movable property. Why? Because we are discussing Sale of Goods Act, and goods are always and always movable property, and immovable property will never be classified as a good. Okay, and neither actionable claims or money. So it has to be goods only, and that to a movable property. Okay, so now what is not a movable property is not covered here. Okay, actionable claims though are the piece of paper. They are movable like anything, but they are not considered property, so they are not a part of movable property. It may be either existing goods owned or possessed by the seller or future goods. Yes, very well. It may be right now in the possession of the seller, or seller may get the possession later on and deliver it to you at a future date. It may happen, no issues. A price in money, not in kind, should be paid or promised, but there is nothing to prevent the consideration from being partly in money and partly in kind. Okay, for sale to happen, the price should be paid in money, not in kind. Like it cannot be a barter system, it cannot be an exchange. Okay, it cannot be an exchange, it cannot be a barter system. You take my swing, I'll take your pot. Okay, this can't be the condition here. It has to be in the money, or it may be partly in money or partly in kind. Okay, because purely if it's in kind, it is called an exchange. It is not a sale, it is merely an exchange. Okay, so it is merely an exchange. An exchange is never a sale because you can always claim your property back. So it has to be in the terms of money. It may be partly in the kinds and partly in the money, but money factor has to be compulsorily there. A transfer of property and goods from seller to buyer must take place. The contract of sale is made by an offer to buy or sell goods for a price by one party and the acceptance of such offer by the other party. Just like any other contract, like we discussed in the Indian Contract Act, there has to be two parties. One will make an offer, other will accept that offer, and the contract is complete. Similarly, in a case of transfer of property in goods from seller to buyer, there has to be an offer from the seller or buyer and acceptance from the other party. A contract of sale may be absolute or conditional, like we discussed. It may be absolute, happening immediately without any conditions involved, or it may be conditional, like I want a red color car, or I want a plasma TV, or I want 100 bales of cotton of this grade. Okay, grade has to be different. Okay, like it may be conditional, or you have to make the delivery at Gujarat, something like this. So conditions may be there. A contract of sale may be absolute as well as a conditional, no issues. All other essential elements of a valid contract must be present in the contract of sale, like competency of parties, legality of object, and consideration. Needless to mention, when we are talking about a contract of sale, definitely all the elements which are essentials of a contract must be prevalent in any other contract in India, not only in contract of sale of goods but any other contract. So definitely the essentials are applicable here as well. Parties must be competent, object must be legal, consideration has to be there, and impossibility should not be there. It should not be banned, and this and that. Whatever all essentials we did, they are applicable here as well. Now, let us distinguish the sale and an agreement to sell, though we have done it in a very detailed manner, but we'll still read the differentiation provided by the book. Okay. So now basis of difference, because sometimes you may be asked about this question: what is the difference between a sale or an agreement to sell? And this tabular representation will definitely help you in hitting the bullseye, and you can definitely understand the definition in a better manner, the distinction in a better manner rather than in a paragraph format. This tabular representation is always a better one. So now the table is divided into, split into three rows. Okay, three columns, sorry. First is basis of difference, then the sale, then the agreement to sell. Let us read them one by one. The basis of difference is transfer of property. In the sale, the property in the goods passes to the buyer immediately, like we discussed. Immediate transfer will take place. Property in the goods passes to the buyer on a future date on fulfillment of some condition. Because it is an agreement to sell, definitely something will take place on future date. Nature of the contract. What is the nature of the contract? It is an executed contract. Okay, like we did in the contract, executed contract as well as an executory contract. Executory contract is something which is going to take place in future. Executed, which is complete immediately. It is an executed contract since sale is immediate. Contract for which consideration has been paid. Since agreement to sell is going to take place in future, it is an executory contract yet to be executed, yet to be completed, discharged. Contract for which consideration is to be paid at a future date. Remedies for breach. Okay, what are the remedies for breach? The seller can sue the buyer for price of the goods because of the passing of the property therein to the buyer. Now I have taken the delivery but I refuse to pay the money. Now seller can make a claim against me that since I have supplied you the property, you must pay the money to me. Okay, now seller has a right here and buyer has a liability. In this case, the aggrieved party can sue for damages only and not for the price. Okay, because sale has not taken place. In agreement to sell, sale has not taken place, property has not transferred. Okay, the only thing they can do is for damages, that whatever damage you may suffer in the regular course of business because of the default of the party in performing its part of the contract. Liability of parties. A subsequent loss or destruction of goods is liability of the buyer. Okay, so if any destruction or loss happens to the good, the liability is of the buyer only. Okay, I have purchased a car, so tomorrow my car meets an accident, whatever damage happens to the car, it is my responsibility. Okay, such loss or destruction is the liability of the seller only, because sale is yet to take place, the property is still with the seller physically as well as property in goods, both are with the seller. So if some risk occurs to the property or goods, the risk is with the seller only. Nature of rights. Creates just in rem, it creates just in personam. Nature of rights. Just in rem means, just means right. Okay. Now this word just, it's a Latin word which means right. Okay, just means right, and rem means remedy. Okay, personam, person. Okay, so just in rem, it means right against whole world, whole world. Okay, just in personam, it means right against a particular person only. Okay, right against a particular person only. So just in ram is a wider right, just in personam is a very narrower right. So because sale has taken place and now I have become the owner of a property, now anyone makes any damage or makes any change to the to property belonging to me to my disliking and without my authorization, I have a claim against that person. I have a right to file a case against any person in the world. Okay, now today I hold a laptop, anything is committed to my laptop without my permission, anywhere in the world anyone does it, I have a right against that person. I can file a case against anyone in the world. Okay, no specific person is to be there. Anyone who transgresses into my property, I can file a case. But this is just in personam because it is agreement to sell. It is an agreement to sell, and there are only two parties, so you have a right against the person only right now. Because sale has not taken place, you have not become the owner. You have a right to file a case against a particular person. Seller can file a case against buyer only, that he is now not buying the product he promised to, or buyer can file a case against seller that he is not delivering the property to me. Okay, you do not have a, it's a very restricted right, it's a very wider right. So nature of right, sale, because you have now become the owner, you have a just in rem. Okay, just in rem is always with the owner. Here it is an agreement to sell, so it creates just in personam, right against the person only. Right to resale, the seller cannot resell the goods. Okay, now right to resale, who can resell it? No one can resell it. A sale is one, sale takes place only once. Okay, I bought a car. Now, for seller's part, he has sold it to me. Now, if I sell it to someone else, it is now again a sale from my side. It's not reselling. It's now I am selling it from my side. Okay, so there is no reselling available here. It can only be sold once. But here, because seller, since he has the goods, okay, and seller has not been paid, so he can resell the goods to someone else because he still is the owner. There is an agreement to sell, and I have an agreement that TV owner will provide me TV on some date and I will make the payment. If on that date I do not make the payment, he is free to sell that TV which is still with him to somebody else. So their seller can resell the property to someone else, and he may also keep the advance money. Sale distinguished from other similar contracts. Now we have discussed difference between sale and agreement to sell, but there may be other kind of agreements which may appear to be sale but are not sale at all. They have some elements of the sale but they are not sale. Now let us understand different kinds of agreement which are different from sale though they appear like a sale. One such is, first of them is sale and hire purchase agreement. Sale and hire purchase agreement. A contract of sale resembles with contract of hire and purchase. A contract of sale resembles a contract of hire and purchase. What is contract of hire and purchase? We'll understand very closely. And indeed, the real object of a contract of hire purchase is the sale of goods. Ultimately, okay, the ultimate object of contract of hire and purchase is to culminate itself into a contract of sale. Okay. Hire purchase agreements are governed by the Hire Purchase Act 1972. We have a special act known as Hire and Purchase Act 1972, which regulates the hire and purchase agreements in India. The term hire purchase agreement, okay, hire purchase agreement means now what is a hire purchase agreement? Let us read. It means an agreement, okay, it's an agreement under which goods are let on hire and under which the hirer has an option. So goods are, first of all, under hire and purchase agreement, goods are given to someone on hire. I am hiring someone's good. Okay, I am not becoming owner. I am not buying them. I am only hiring them. Goods are let on hire and under which the hirer has an option to purchase them in accordance with the terms of agreement. Okay, now I buy a car. Now we have a car subscription services. If you people are aware, we have subscription services with the cars. Okay, car subscription. Okay, in this car company will say you pay me 40,000 rupees per month and you drive home the car, keep the car and pay till the time you wish to for every month, and if you do not wish to pay anymore you return the car to us. This is I am hiring their car. Okay, so now they also have an option that in case you keep the car for 48 months you shall become owner. Okay, so if I keep the car for 48 months, I shall become the owner. But if I keep the car only for 47 months, okay, and I do not pay the 48 months installment, I will not become the owner. The property will go back, revert back to the car provider. This is a hire purchase agreement. I hire it, and if I wish to purchase it, I have to fulfill those conditions like for 48 months, I'll have to keep it. So if I keep it for 48 months, I get to keep it as my own car, otherwise I'll have to return it as a property of the car subscription service provider. And includes an agreement under which possession of goods is delivered by owner thereof to a person on condition that such person pays the agreed amount in periodical installments like we discussed, EMIs, monthly payments. Okay, it may be quarterly as well, maybe biannually, maybe annually. Okay, it may be biannually, it may be quarterly, it may be monthly, it may be weekly, it may be annually, it may be semi-annually. Anyway, it may be adjusted. It is purely upon the seller and the buyer. But issue is possession of good is delivered. Only possession. Okay, only possession, not ownership. Very key word here to understand. Only possession or control. Okay, only possession or control, not the ownership. Okay, in other words, we can say it is transfer of goods, not transfer of property in goods. Because transfer of property in goods is ownership, transfer of goods is mere transfer of possession or the control of that particular good. The property in goods is to pass to such person on payment of the last of such installments. Like I discussed, that if you pay 48th installment, property in goods will pass to you. That is, I will become owner of the car. Okay. Such person has a right to terminate the agreement anytime before the property surpasses. Nonetheless, a sale has to be distinguished from hire and purchase as their legal incidents are quite different. Okay, such person means who is the person? The one who has hired it. The hirer has a right to cancel the agreement anytime he wishes to. He can return the car after paying the installments for whatever amount he has used. Okay, he has a right. The car company cannot compel him to buy it, or the hirer or the person who has given the product on hire cannot compel the other one to buy it. Okay, there can be no compulsion, just like a agreement to sell there is a compulsion. Okay, so now let us understand basic differences between an agreement to sale and a hire purchase. Okay, sale and hire purchase, because both have different connotations, so it is important that we must understand the difference between both of them. Okay, first one is sale. Sale is property in goods is to be transferred to the buyer immediately at the time of contract, like we know. Hire purchase, the property in goods, that is ownership, passes to the hirer upon payment of the last installment. Okay. Then position of the party. Okay, what are the position of party in the sell in the contract of sale? The position is of the buyer is that of the owner of the goods. Buyer will become the owner of the goods upon completion of sale. But here the hirer is only a bailee. He is only using it. He is only a user, but he is not the owner. He will become owner only upon the fulfillment of conditions like last installment. Termination of the contract. Sale when complete cannot be terminated. Okay, The buyer cannot terminate the contract and is bound to pay the price of goods. Contract of sale, when it is complete, okay, the buyer cannot terminate it. Even if it's not complete, buyer cannot terminate it. He'll have to pay damages, okay. The hirer may, if he so likes, terminate the contract by returning the goods to its owner without any liability to pay the remaining installments. On the other hand, here the hirer who has hired the goods can terminate the contract anytime and return the goods to owner. Burden of risk of insolvency of the buyer. Burden of risk of insolvency of the buyer. The seller takes the risk of any loss resulting from the insolvency of the buyer. Okay, seller takes the risk. Okay, because suppose seller has the property, okay, and there is a contract to sell. Okay, there's a contract to sell, and now somehow before taking the delivery or making the payment as well, seller buyer has become insolvent. So now buyer has become insolvent. That means whatever buyer owns will go to the creditors. So now the property kept by the seller, now he's keeping the property for buyer, but buyer has not paid. Okay, but the transfer in property has taken place because he has earmarked it. So now the property will go to the creditors and no money will be paid to seller. The owner takes no such risk, for if the hirer fails to pay an installment, the owner has right to take back the goods. Okay, because in this case there is no such risk, because the moment you miss your installment, the owner will take back the goods from you. Transfer of title. The buyer can pass a good title to a bona fide purchaser to him. Okay, buyer can pass a good title. Definitely buyer can sell it. Passing of title means selling it. So buyer can definitely sell it. The hirer cannot pass any title even to a bona fide purchaser. Hirer cannot pass any title at all, because hirer does not have any right to sell it or pass the title. He has only a right to use it. That's it. Resale. The buyer in sale can resell the goods. Okay, the buyer can go and make another sale. The higher purchaser cannot resell unless he has paid the installments. Okay, for higher purchaser, he has to first pay the last installment, then only he'll become the owner, and then only he can sell it. Otherwise, he cannot. Now the other one is sale and bailment. Okay, now the other kind of transaction which is different from sale is sale and bailment. Now what is bailment? Okay, let us read. A bailment is the delivery of goods for some specific purpose under a contract on condition that the same goods are to be returned to the bailer or are to be disposed of according to the directions of the bailer. Okay, now that means goods are being delivered to someone with specific directions, and that ultimately later on they have to be delivered back to the owner. I'll just give you an example so as to make things clear to you. Okay, now who owns the car? I own the car. Now what I do, I give hand over my car to the mechanic for making some repair. Mechanic says come back after 3 days. I'll take 3 days in repairing your car. Now I am the bailer and the mechanic is the bailee. Okay, the mechanic is the bailee. This is a bailment. Okay, I have given the property for some specific thing. Okay, for making repairs, and then it has to be sent back to me. Okay, I give my cloth to the launderer for laundry, for cleaning them. Okay, with the specific directions that you have to clean them and return to me. There is specific direction. It is not that he can wear them or he can resell them or he can make some cuttings and some clippings or alterations into them. No, the specific directions are only for cleaning, and he has to just clean them and do nothing else other than what he is supposed to do. That is called a bailment. It is called a bailment. Now, what is the difference between a sale and a bailment? Let us understand. The difference between bailment and sale may be clearly understood by studying the following. Let's study the following now. Basis of difference: transfer of property. Okay, in sale, the property in goods is transferred from seller to buyer. In sale, the property in goods is transferred. In bailment, there only transfer of possession of the goods from bailor to bailee for any reasons like safe custody, carriage, etc. Okay, safe custody means I put my goods in the cold house called storage or warehouse. Okay, because I do not have storage, so I hire someone else's warehouse and I keep my goods there. Or carriage means I give my goods for the to the train to transport it to some other location. These are carriage. In bailment, only goods are transferred, not the property in goods. In sale, the property in goods is transferred. Return of goods. The return of goods in contract of sale is not possible because buyer, once he has taken the delivery, he's not entitled, he's not bound to return the goods to the seller. Okay, in the bailment, the bailee must return the goods to the bailor on the accomplishment of the purpose for which the bailment was made. Okay, in the bailment, the bailee must return the goods. Okay, to the bailor. Definitely because mechanic has to return the car or the launderer has to return the laundry. That's it. Consideration. The consideration is the price in terms of money. In sale, the consideration is the price in terms of money. In bailment, the consideration must be gratuitous or non-gratuitous. Okay. The consideration may be gratuitous or non-gratuitous. It may be free of cost or it may be by some money. Like I give the car to mechanic, I'll pay him something. Okay. But that is gratuitous. Okay, when my friend takes my car for 2 days, I give him my car. It's okay, you keep it. That is gratuitous. So the bailment may be free of cost or bailment may be due to some money. Sale and contract for work and labor. Now, sale and contract of work and labor. A contract or sale of goods is one in which some goods are sold or are to be sold for a price. Okay, you are trying to sell some goods. Okay, but where no goods are sold and there is only the doing or rendering of some work of labor, then the contract is only of work and labor and not for sale of goods. That means I am providing services. Simply stating, I am providing services, I am not selling my goods. Okay, there are two kinds of things like we have GST, goods and services tax. So, one is goods, what we are discussing here, other is services, that is work and labor. I am a lawyer, I go and appear for someone in the court. I am not supplying any goods, I am supplying my services. I am a tutor. I go and deliver lectures. I am supplying my services. Okay, so that is a contract for work and labor. There is no sale there. It's only a contract for supplying services. Okay, it's not a it's a sale. It's not a sale of goods. It's a sale of services. Definitely, it is a sale. What if you are selling your services? You are definitely selling it, but it's a sale. But it's not a sale of goods. It's only a sale of services. Where the gold is supplied, example is where a gold is supplied to goldsmith for preparing an ornament or when an artist is asked to paint a picture, they are just providing their services.